The living court, how to operate as a court of record in your private capacity. 1. The executor as court. A true court isn't a room, it's an office, the office of record. When you act as executor, your declarations, notices, and seals are the proceedings. You stand as the clerk, the magistrate, and the witness to your own record. So what does that actually mean? It means you stop looking for the court, because you already are one. A court of record is defined by two things: a living clerk who records acts, and a record that speaks for itself. The executor satisfies both. Every document you issue is an order, and every unrebutted record becomes decree. Footnote: the executor operating in private capacity fulfills all elements of a court of record through living authority and self-authenticating record. 2. Proceedings by paper. In a living court, the process is written, not spoken. You don't argue, you issue. Each filing is a procedural step: notice, fault, default, judgment. The sequence replaces hearings, and the mail replaces the gavel. So what does that actually mean? It means your envelope is the bench. By sending each notice through certified or registered post, you create verifiable service, timestamped jurisdiction, and an unimpeachable audit trail. Your docket is your binder, your minutes are your receipts. Footnote: written proceedings and certified mailings constitute lawful acts of a private court, replacing oral litigation with verifiable administrative record. 3. Clerkship and custody of record. Every court needs a clerk, and in private law, that's you. The clerk's duty is custody: keep every original, note every service, log every signature. The record's integrity is the measure of the court's honor. So what does that actually mean? It means neat handwriting now counts as jurisprudence. Chronological order matters. Each event must be dated, initialed, and sealed. When done properly, any reviewer, judge, auditor, or trustee can trace the entire history of the controversy without question. Footnote: maintaining chronological custody of documents secures authenticity and establishes administrative transparency of the private court. 4. Oath and honor of office. A living court is founded on conscience. The executor's oath is simple: do no harm, act in honor, and record truth. Unlike statutory officers, the private executor swears not to a state, but to equity itself. So what does that actually mean? It means your signature is your oath, and your seal is your conscience. This alignment of moral and procedural integrity is what grants your record its weight. Without honor, paperwork is just stationery. With it, paper becomes law. Footnote: the executor's oath unites moral intent with legal function, granting equitable authority to private judicial record. 5. Final authority, when the record speaks for itself. The last principle of the living court is silence, not of neglect, but of completion. When the record speaks, the executor remains silent. Law, once perfected, requires no debate. So what does that actually mean? It means the quiet in your office is the sound of judgment being entered. When every notice has been issued, every default certified, and every seal affixed, your record stands as the living judgment. The world may call it paperwork, equity calls it truth. Footnote: completion of the record closes jurisdiction. The perfected file itself serves as the final judgment of the living court.